The debate over the meaning of general welfare was about the things on which Congress could spend money. The debate over the Commerce Clause, meanwhile, was about the ways in which the federal government could regulate Americans' behavior. It sounds simple. The Commerce Clause says that Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. The meaning is obvious, isn't it? The states of the new Union couldn't be permitted to set themselves up as independent economies, with, say, Pennsylvania charging tariffs on rice imported from South Carolina. That's the kind of chaos that had happened in the bad old days under the Articles of Confederation, and the Constitution allowed the federal government to prevent it. Commerce, as used at the time of the founding, referred to buying, selling, or bartering, as well as transporting for those purposes. It did not refer to manufacturing or agriculture, let alone to any broader definition of commerce as gainful activity. Constitutional scholar Randy Barnett has documented that all known uses of the word commerce in the Constitutional Convention, the ratification debates, and the Federalist, literally 100% of them, applied the narrow meaning of the word. The phrase, among the several states, follow me closely here, surely meant that more than one state had to be involved. Throughout the 19th century, the Supreme Court's decisions involving the Commerce Clause, summarized in the note, were broadly consistent with a common-sense understanding of what the founders had in mind. From the turn of the century to the New Deal, the progressives made inroads on the prevailing understanding of the Commerce Clause in a series of cases that broadened its interpretation to include railroads that operated within a single state under certain circumstances. But railroads were a special case, more likely to have monopolistic power in the marketplace than other modes of transportation. An observer at the outset of FDR's administration could reasonably think that the Commerce Clause still meant more or less what it had always meant. In 1937, the court ruled that the National Labor Relations Act was constitutional. The challenge to it had come from Jones and Laughlin Steel Corporation, which was being fined because it had fired employees who were trying to form a union. The court ruled that manufacturing fell within the purview of the Commerce Clause, and that the definition of interstate was broad. Activities that occurred within a single state could be regulated by federal law if they had a close and substantial relationship to interstate commerce. This represented a huge expansion of the meaning of the Necessary and Proper Clause. The Congress shall have power to make all laws which shall be necessary and proper, as it related to the Commerce Clause, gathering all forms of manufacturing into its embrace, along with anything that had indirect effects on interstate commerce. It was left until 1942, in Wickard v. Filburn, for the Supreme Court to complete its redefinition of the Commerce Clause. Roscoe Filburn was a small farmer in Ohio. He had been fined by the Department of Agriculture because he produced 239 more bushels of wheat than the Agricultural Adjustment Act said he was supposed to produce. None of Filburn's wheat was sold outside Ohio. In fact, hardly any of it was sold at all. He used most of it for feeding his family and for feeding livestock, which he subsequently sold as meat. But the Supreme Court ruled that the provisions of the Agricultural Adjustment Act were constitutional under the Commerce Clause anyway. After all, if Filburn had not used his own wheat, he would have had to buy it. If enough farmers like him had to buy their own wheat, it would have an effect on the price of wheat, and the price of a commodity has an effect on interstate trade. So it's constitutional for the federal government to tell a farmer what he may grow on his own land for his own use. In effect, the Supreme Court announced to the nation that the federal government could regulate just about any economic activity of any sort that it felt like regulating. Indeed, as subsequent decades were to reveal, It could regulate even non-economic activities that had potential effects on economic activities that had potential effects on interstate commerce. And so, as federal judge Alex Kozinski has put it, the Commerce Clause became the "hey, you can do anything you feel like" clause.